Good afternoon, everyone, and welcome to the webinar, Investigating and Prosecuting Trafficking in Illicit Massage Businesses, Prosecution Strategies, Part 3. My name is Emily Thrush, and I'm the project coordinator at AEquitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will provide an overview of how trauma impacts victims of illicit massage businesses, IMBs, in addition to practical trauma-informed interviewing techniques that help us develop stronger and more understandable narratives. The presenters will also discuss making appropriate charging decisions, litigating pretrial motions to protect victim privacy, establishing the elements of the charges with or without victim participation, and educating the jury through voir dire, expert testimony, and effective witness examinations. Before we begin the substantive portion of our program, I will provide a few logistical notes. If you have any technical difficulties, please contact iLink directly at 1-800-799-4510. And if you're using the internet audio option, we do recommend you dialing in with a phone. I've put the phone number and passcode in the public chat section so you can look at it there. You can also chat me any questions you have using the private chat function on the left-hand side of your screen below the attendee list if you have any questions during the webinar that you'd like me to put to the presenters, or we can follow up with you afterwards. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, and Polaris, through funding from the U.S. Department of Justice Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation from today and the presenters' full biographies, will be emailed to you after the presentation. In addition, we are recording today's webinar for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas staff conducts legal research, provide 24/7 case consultation, we host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and publish resources on topics relevant to the prosecution of violence against women. The individualized assistance that AEquitas provides is data-driven and incorporates customized strategies that are easy to implement, resulting in prosecutors' ability to sustain effective practices and promote systemic change. Polaris is a leader in the global fight to eradicate modern slavery. Named after the North Star that guided slaves to freedom in the U.S., Polaris systemically disrupts the human trafficking networks that rob human beings of their lives and their freedom. Their comprehensive model puts victims at the center of what they do, helping survivors restore their freedom, preventing more victims, and leveraging data and technology to pursue traffickers wherever they operate. Today's presenters are Jane Anderson, Attorney Advisor here at AEquitas, and Oriene Shin, Strategic Initiatives Specialist at Polaris. Prior to joining AEquitas, Jane served as an assistant state attorney in Miami, Florida, where she was a founding member of the Human Trafficking Unit and the prosecutor on many of the state's first trafficking cases. Now, as an attorney advisor with AEquitas, she provides training, case consultation, and resources for prosecutors and allied professionals handling human trafficking and other cases involving violence against women. Oriene Shin is a specialist for Polaris' End Trafficking in Illicit Massage Business Strategic Initiative. She works with key stakeholders across the country to address types of human trafficking and protecting trafficking victims in their community. Her focus has been to review and analyze policies, state and local level laws, and regulations to better identify and recommend promising practices to stakeholders. We also want to acknowledge Brad Myles, the CEO of Polaris, who contributed to this project but cannot join us for today's webinar. The full biographies for Jane and Oriene will be emailed to you following the webinar, along with a PDF of today's presentation slides. And I now turn the floor over to Jane for the substantive portion of our presentation.
Thank you, Emily. Welcome, everyone. Welcome back, those of you that have joined us for parts 1 and 2 of this webinar series. If not, they are recorded and available on our website. They did cover just some basic information about IMBs, their structure, their network, and sort of the idea that they are part of this larger criminal activity. We talked about the distinct harms that women working in IMB suffer and their unique service needs. Then we spent part 2 really talking about true partnership that can be leveraged with community groups, with different law enforcement, code enforcement partners, and how to really build and investigate these cases so that when we're bringing them to the prosecutors, there can be a successful prosecution through all of this additional evidence collection, really sort of taking it away from maybe more traditional investigative means. I will warn everyone today, part 3, we did try to cram in a lot of information. I think it's all really wonderful. The slides are full of details that we may not cover one by one, but will be provided to you in PDF handout form. And Oriene and I are both really open to follow-up questions should we sort of run out of time at the end of today. So with that in mind, we'll move forward. Today, we're really going to talk about implementing this trauma-informed practice and taking particular amount of time looking at interview techniques that are going to minimize re-traumatization and hopefully maximize getting the details that we need to move forward in prosecution. We'll talk about some pretrial pieces of our trial procedure, including discovery, privacy issues, and sort of how to preview evidence for a judge so that when we come in front of a jury, there's a better understanding of what our cases look like. And then throughout all of this, we're really going to focus on how these offenders' behavior are really what needs to be taken into account as trials move forward. Oriene's going to start off with taking a trauma-informed approach.
Thank you, Jane. So just to begin real quickly, we're going to be going through the trauma-informed approach where we're going to first talk about the effects of what trauma can do to a victim of human trafficking, and then talk a little bit about how or what practices we can use and implement to alleviate some of the traumatic experiences or reactions that can happen or behaviors in order to conduct a more comprehensive interview and really get to the heart of the interview process, as well as talking a little bit more about how to go about interviewing the victims of trauma, in this case, victims coming out of illicit massage businesses. Before we get started, I would like to acknowledge all of the amazing people that have helped us, from the Safe Center in Long Island to Polaris's own client services department. Tabitha Gallerani and Pui Feng are two amazing individuals from Safe Center Long Island who have provided services to over 100 Chinese women that were in IMBs. Pui specifically speaks Cantonese and Mandarin and has provided some of the culturally specific information included in this webinar. Willa Morris and Kara Romero are two of our case managers and direct client services members here, staff members here, who have also contributed a ton to my own understanding of what trauma-informed care looks like and what their experiences serving women directly have been here at Polaris. So just to begin, what is trauma? The term trauma has been used in the mental health field, to describe the intense psychological and physiological responses to a stressful situation that causes a lasting negative impact on an individual. Trauma is experienced when the stressful stimuli or experiences overwhelm the person's ability to effectively cope with the situation, and therefore severely impacting a person's ability to function. And so when we say trauma, we're not talking about these really lasting effects from a traumatic or very incredibly stressful situation that you will always see in human trafficking situations. So the impact of trauma can really manifest in a number of ways, both physically and psychologically. Physically, when we're talking about the memory, a traumatic event floods the body with hormones, and it prompts this fight, flight, or freeze response where the victim really doesn't know, where the victim goes into a really instinctual place in their mind, and that really can negatively affect our memory. And so often what we see with trauma-based victims with who have experienced deep trauma, oftentimes we'll see incomplete recollection or fragmented memory. So the stories won't always come out in a sequential or a comprehensive way. In addition, regulatorily, the body really does respond to the trauma, because that is an instinctual survival response that all humans have, where oftentimes a sense like smell or touch or taste will become attached or connected to the traumatic experience, which is really one of the body's ways to prevent this from happening again. And so difficulty regulating physiological or emotional responses is common. Emotionally, we have also seen that trauma can impact the survivor's behavior, self-identity, and relationship. With the behavior, survivors of trafficking may exhibit behaviors that are drastically different from their normal behavior, and these changes may include angry or hostile tendencies, as well as social phobias or just abnormal patterns of habit. Relationships are also impacted, where it really can negatively impact the way a victim relates to others in the future. The pattern of abuse from a trafficker may lead to a survivor to be either not trusting of strangers or extremely self-reliant, while others become overly dependent and trusting of others. And then self-identity, victims of human trafficking may not have been convinced to believe that their situation is their own fault and may begin to internalize the blame and shame. And this is something that we do see from women coming out of IMBs, where they refuse to self-identify or they blame themselves for the situation that they're in. And so all of these different ways can be the effects of trauma or the traumatic experiences that victims of human trafficking experience. And here's just another slide to really just summarize the different types of responses that you could see in a victim when first meeting them. And really, this is really to show and begin to understand the kinds of physiological and psychological impacts that trauma can have, and to really have these in mind when going into an interview situation. So next, I really want to quickly go through some trauma-informed practices, where I'd like to first talk about how important trauma-informed practices are, because the better trained we all are in this, the better and the more positive engagement skills that we use, the easier it will be to work with victims of trafficking. Because it is also incredibly important to remember that the interview will likely not know what might trigger a victim to relive their traumatic experience, or know to what extent what the trauma has been in their situation. The priority of a first responder should always be to do no harm, and the first step is to recognize when harm is or has been done to a victim. Working with service providers. I know in our audience, we have a lot of law enforcement prosecutors, and this is a slide that I would recommend you review to really understand the different characteristics, or some of the characteristics to look for when working with a victim advocate or a service provider who is trauma-informed. Especially with IMBs, it is very important, and we highly recommend that specialized knowledge of what an IMB individual or what their experiences are is important, as well as cultural sensitivity and language accessibility, i.e. interpreters, we're finding to be a very integral part of the interview process and the practices to speak to women coming out of IMBs who have experienced this kind of trauma. And why is this important? Well, the power of the service provider can provide you with all of these different positives, especially when trying to work with a victim and really try to understand the situation that they were in. First off, the service provider can really help to build the confidentiality and the trust in the system. We do know, as we've talked about in webinar 1, that a lot of women coming IMBs don't trust law enforcement or service providers, even in the United States, because of their preconceived notions. And so working with the trauma-informed service provider can really start breaking those barriers down and provide enhanced participation, more consistency, as well as direct services that the women will need to continue on with their healing process. And so that's where the service provider is incredibly important in the interview process. And here are just another couple of things, just to really, just a list of things how a service provider and the victim can really help with the building of rapport with the victim and building the trust, and how a service provider can help others to really lean on them and really begin to help with that process. And I believe Jane will go through a little bit more about interview or interrogation versus interrogation. Jane? Okay, there might be some...
Sorry.
Oh.
Sorry, guys. I was talking without you. Thank you, Ori, for letting us know all about that trauma-informed practice. And I think it really does. It's important to everyone in the system to know all of those things, because if one link in the chain isn't trauma-informed, it can sort of break down the entire process. So speaking from like more of the law enforcement prosecutor side of things, we really need to step back and look and say, okay, we're not doing an interrogation. This is an interview. And what does that mean? First off, take all those interrogation techniques that you learned in the academy and throw them out. Interrogation techniques tell you to focus on details, get a really tight timeline out there, try to figure out where they're lying, catch them in a lie. This is exactly the opposite of what we need to do when we are talking with victims of any trauma, and especially victims that are brought out from IMBs, where they have been inculcated that the police are bad and not there to help and they're in trouble. So really follow the lead of the victims, and it starts with the conditions. In a neutral location, well away from anyone else that's in that IMB, including who you might think are other victims, because you really never know what the dynamic is inside, who is the mama-san, who's maybe been there longer and maybe more involved in the management. So really neutral location, be cognizant of those power dynamics, right? So if you can alleviate that by, not being in uniform, being in a place that doesn't look like an interrogation room, take plenty of breaks, schedule these around people's needs. We don't all have the freedom that we would like, but consider all of these things when we go forward. Now, I think Oriene and I are going to talk about the next couple of slides together, because this really is a big issue that I think all of you are going to come across, and you may come out on different sides of the fence or maybe find some other solution. And this is, should the victim advocate be present in law enforcement interviews? And there are pros and cons, and we have two major ones here on this slide, but that is not by all means exclusive. The pro is, hey, we're building rapport, we're building trust. Let's have this person in the room with us so they can feel more comfortable and safer. And we really want to promote that. A major pro for a victim advocate to be in the room. One of the cons is that confidentiality is always broken when there's a third party there, which means that that statement and all those people that are a witness to the statement may be called to testify and absolutely must be listed on a witness list. So that's the sort of tension that we see. And I think, Oriene, you would agree with me on all of these points, that really we talk about victim-centered, and one of those things is that victim needs to be in control of as many aspects of their self-determination as possible, and that includes how this interview looks and who's there and who's present. However, the problem is that we need to make sure that the victim and the advocates are also fully aware of the ramifications of that. So when they're making that decision, hey, of course I want my victim advocate in this room. Of course this is what's most comfortable for me, that they really are aware of what those ramifications might be down the line. So I think that, okay, go ahead, please, Oriene.
Sorry, absolutely. And one thing I would just add is that Polaris would recommend all of the, that law enforcement do go over the limitations with service providers. But to really just make it a neutral statement and really just to inform them instead of trying to bend it one way or another. From Polaris' stance, just so you know, we are very much a self-determination of the victim, and restoring the woman's agency is critical and central to all of our practices here. And so for us, if the woman says once that they would like their individual there, that's when I think Polaris would recommend the advocate remain in the room. And that's all I just got to say for that.
Yeah, and I think one of the ways that we can sort of eliminate this being a problem is by having this conversation often and way in advance. Really sit down, advocates, prosecutors, law enforcement, part of that team, part of that, working together, sit down and be like, what are we going to do with this situation? Advocates, here are exactly the ramifications potentially for your confidentiality. Potentially you may be called as a defense witness. I'm going to leave it up to you as an advocate to talk to your client about that so your client's making the best decision for themselves. Fully understand those consequences. Think about alternatives that might, sort of help the victim remain confident and comfortable without breaking confidentiality. But at the end of the day, what do we do when the victim, in her every right that she has, says, you know what, I'm really not going to have an interview unless I can have my advocate here. That's how I really want to go forward. What are you going to do in that circumstances? And have that conversation way in advance. And I think law enforcement and advocates that I know that have worked together on these things, they come up with this and it works. It's when it doesn't work is when we haven't thought this through together. So some of the things that mitigate, I think this might be yours, Oriene, but
We're good.
to mitigate the trauma that we have, one of the common things we have listed here is to have the little playthings. We have sensory items or fidget toys available. I hear over and over again that that's one of the easiest, quickest ways and most successful ways to mitigate the trauma for a victim that's going through this. But we have some other things here too. And one of the other things we end here is do not make promises you cannot keep. I think we are instinctually, we want to say, hey, everything's going to be okay. We're going to get the bad guy. I promise you. And once these individuals who have had broken promises their entire lives, once they see you as another person that can't keep their promise, that trust and rapport that you spent all this time building is going to be broken. We also want to make sure that we're really sensitive to the cultural and linguistic issues that are happening. So using trained interpreters that are sensitive to the situation. This isn't a situation where you can just bring an interpreter and sit them down. You need to have a conversation ahead of time. You need to make sure they know what the circumstances are. They need to make sure you're using the correct language and that you're also being aware of what the language that the client is most comfortable using. So honor that by mirroring the words that they're using. So if they're not comfortable with certain words, then we use what the victims are using. This is just an example, and I want to again thank Tabitha Mpuyi for this. For the work, the survivors that they've worked with are mostly Chinese in descent, and there's a phrase that says, one never steps through a government's office door in one's lifetime and never goes to hell after death. And essentially it says going to the police is sort of akin to going to hell. So this is going to be easily reinforced. This traditional thought is easily reinforced if their experience with police here in the United States is sort of reinforcing that, whether it be through arrest or being through really hard-nosed tactics. And they really have a very difficult time breaking this very traditional, very ingrained sense that police equals hell with, hey, this police officer is offering me some help. So just as a distinct example here, I wanted to bring that to your attention. So law enforcement, we're building rapport, meeting physical needs above all else, and that means, clothing, housing, food. If you don't meet those needs, you're never going to get to the next things that you need. So, and again, asking sensory-based questions to get the most details possible. But this is really a different approach. We're asking you to do something different. We're asking you to say, hey, I'm not going to get all the information I need in one interview. I know that. I'm going to have to spend some time with this. I'm not going to force these details because if I force them, I may get the wrong details. Somebody may just be wanting to give me the answer to make me stop asking questions, but also really understanding all that trauma and the neurological effects of the trauma that Oriene started out great with in this particular webinar. Go ahead.
Oh, go ahead.
No, that's you. Sorry.
No worries. This quote is just to reinforce what Jane was just talking about how a victim of human trafficking really can how they internalize the trauma and how it can impact them mentally, emotionally, and physically. And so this is just to reflect that this is what can happen, where they don't remember it sequentially. They will remember it in bits and pieces, but so it's something that that will require some patience. But overall, this is going to happen with a deeply traumatized individual. Okay, so for the initial interview, we recommend that this initial interview should really be about trust building, building rapport, and getting the general basic information and really educating the victim about what the next process is going to look like, the next few interviews, and then beyond, and what that's going to really look like. Really more of an informative than a fact-gathering mission type of interview where you're really introducing yourself. One of the things that Jane had mentioned is meet the basic needs of the woman. And one of those things, one thing that we have heard from one of our service providers is never to really provide gray sweats, especially to Chinese victims or other Asian victims, because that is the basic garb that clothing that you will that you will see in Chinese prisons and other Asian country prisons. And so to avoid those kind of clothings, really opt for something a little bit more, something different, but really just all of that leads into this trust building and getting information, getting their name, their contact information, or just getting the very basics of do they know where they are, how old they are, and also to be prepared that not all of this information will be collected at one point, or to be prepared for that not to happen at all. And really just beginning to have the victims understand what their rights are. A lot of times they won't know what their rights are in the States, and it's going to be a critical piece of information for them to know to moving forward. Once the initial interview has happened, we recommend that you really take a couple of days, let the victim really just kind of decompress a little before going into the next interview, but this is where you would really want to do the majority of your information gathering in your in-depth interview. And this is where you allow for the multiple breaks like we were talking about, and really just also following up, hey, have you been able to, have you been eating well, or hey, have you had a good night's sleep, really continuing to build that trust and rapport. And then from here, this is where we hope that the trauma-informed techniques that we've been talking about and doing it in a trauma-informed manner can really result in more information that can be used for the case. Again, we want to stress that this information in-depth interview may take multiple sessions, but also to be cognizant of when, if a multiple session should be a necessary thing. A lot of times there's going to be that struggle between how many do I do versus how many should I do. And so, or how many do I want to do? You can do as many, you might be inclined to do as many as you want, but remember that could also be just as traumatizing. And so just to remember that there is this balancing act that will have to occur with these interviews that, of the victims coming out of IMBs. And just really, and now just to go into when you're interviewing, what do I say? And so there are 5 types of questions on this slide, and it's really to show the different types. We're not really going to go into what to ask or how to, but really more about how to ask and think about the types of questions you're asking of the women. And so from this slide of 5, we have open, closed, leading, follow-up, and summary. Of these 5, we recommend more heavily using 3, open, follow-up, and summary. Closed and leading can result in answers that might only need a pithy or some pithy answer to, but the open, follow-up, and summary questions will really begin to allow the victim to tell their story, which is what we really want them to do. And so we're going to go through these different types now. So first, an open question. It really just invites the victim to talk about as much information as possible. Ask what was a typical day like, and then just give them the time to kind of piece through what their typical day would be like, and so on and so on. And these are just a couple of examples of what an open question could look like. A follow-up question is really what it sounds like, a follow-up question. So if you didn't understand what they were saying, just say, oh, can you clarify what you were talking about here? So you were telling me X. Well, can you clarify what you meant by that? Maybe they said they felt scared. Well, what were you scared of, or what happened, and what made you scared? But also just to be cognizant and be aware of when to ask these questions and not to interrupt the flow of the story. So maybe at a natural break in the story, this is when we would recommend that you use this follow-up question type. Summary questions. This is a really great way for you during the interview to really converse and really also establish a relationship with the victim, saying, so this is what you told me, am I right or am I wrong? And it really does reinforce the trust and reinforce the rapport because it shows that you're listening in. And then closed and leading questions. These we would recommend that you use very sparingly because they're narrow and because a lot of times they can result in you might not want them or anticipate them to be pointed questions, but they might have been, or we would avoid questions completely that are asking, how many men did you sleep with? Those kind of questions we just absolutely would not recommend because that is asking them to relive a point in their time that we don't want them to go back to unless they're ready to. And then recreating the reality, sensory details. These we caution that these questions or these types of questions can trigger traumatic memory, so we do recommend that you use these sparingly. However, it can be very helpful when trying to determine specific facts. A lot of times women might not know where they are, and so it could be a good way to kind of discern if they understand where they are. So can you tell me if it was hot, was it snowing, trying to elicit some of those sensory factors or sensory memories that can really start to illustrate or add to the story that they've been telling you. And I will send it over to Jane to talk more about conducting an offender-focused trial.
Okay, so now we're at the point where hopefully we've got a case together that we can present at trial. And I will say, our goal always is that we present the fullest trial we can, which includes, the women that have been victimized through the illicit massage business, but that may not be the case. If we refer back to part 2, we really talked about how to establish some of the charges that would be non-victim dependent. So we're going to go forward either way, with or without a victim, always making sure that we are focusing on the offender and what the offender did. So one of the things we want to start with is thinking back to those partnerships that we developed in our investigation. So let's look at that and say, okay, are other proceedings scheduled? Perhaps there are some code violations because you engaged your licensing partners, or perhaps there's a federal case or a civil federal case for employment discrimination or whatnot. So we need to make sure that we are continuing that partnership and that we're understanding what any legal impediments are to sharing discovery freely. Other agencies are going to have different rules, so we need to, hopefully we talked about that in advance, and we're continuing to be careful of that as we move forward. Is the information limited? Can we share it? Are there strategic reasons? Are we going to go forward with one case before the other? Are we able to use transcripts? Perhaps an administrative hearing has already moved forward. Is there something from that hearing that we can use to our benefit? And how do we procure the presence of agents from other government agencies at trial? And then restitution. How is that going to affect any plea offer that we have? So we know from the EEOC, for example, that in labor trafficking cases, based on employment, civil proceedings, they've been able to recover large amounts of money, and that money goes directly to the victims of these crimes. So if, the offenders are actually able to provide large amounts of restitution and you're going back to your victims and they are pleased with that, how is that going to influence what kind of plea offer you may want to provide in this case? So all considerations to keep in mind throughout the process. So we encourage you to charge everything that you possibly can within your ethical provisions, because as we know, these cases will take a long time to go to trial. Your victims may be on board, off board, able to participate, and then, really decide maybe they want to even return to their home country. So we want to make sure that we're never left holding the bag, that we have a strong case that we can go forward on. Multiple counts where appropriate, per victim perhaps, per day, per month. Think about how we can really maximize that. And then always think about amending charges as you go forward. I know when I was prosecuting, oftentimes I wouldn't have a human trafficking charge, but I'd have, like a pimping charge plus a money laundering charge. And then after the victim received services, I was able to get the information I needed, and I'd go ahead and I'd amend it and I'd bump it up to human trafficking. So keep that in mind. With all of that, another thing that you've got to really be on top of is your discovery requirements. These cases, more than most cases, are going to include continual discovery, continual evidence, multiple statements. Don't be afraid of the changing statements. You know, really be confident that you can present this to a jury through a trauma-informed lens, through education, through maybe expert testimony. So don't be afraid of those multiple statements. You can explain those away, and they actually go towards the fact that these victims have endured specific trauma. You also may have cases that we're talking about flips or co-defendants that are agreeing to testify. In cases like that, we always have some additional issues that come up. So Brady and Giglio, more than a basic case, are going to be implicated in these cases. So be careful of that. So how are we going to go about this? Number one, pretrial litigation, education, and then really making an effective presentation to the jury so that the jury can really feel that this isn't just some sort of, you know, thing that's happening off in the distance to people that are foreigners that they don't care about. We need to bring it here and really get jurors to understand that direct impact and trauma that's going on in these women. So motions in limine. I really recommend that in all cases, and especially cases that involve violence against women, human trafficking cases, that you really take advantage of your motions in limine. What they allow you to do is they allow you to preview the evidence for the judge. In most cases, judges only really get a very basic statement of facts before they head to trial. And they're being called upon to make very split-second decisions throughout that trial as the evidence is unfolding, you know, sort of real time with the jury. I believe that judges are going to be making better informed decisions if they have time in advance to preview that evidence, to really go through the brief, to talk to their, you know, counterparts on the bench and make the right decision. Because we're talking about complex issues. We're talking about new issues. We're talking about presenting these cases in a brand new way. So judges they need that education too. And the best way to do that is in advance and not in the middle of trial where you're asking them to make that split-second decision. Also helps us prepare for trial, helps us get a clean trial, and allows us to advise witnesses if there's any limitation on their ability to testify to certain facts or things like that. And also just for us as trial practice, it requires us to really carefully consider every facet of our case in advance, and it'll make us better practitioners. So Rape Shield will be implemented here. This is the advisory committee notes from the federal Rape Shield law. There is a version of this in every state in the country, and it really goes to the heart of why this is a law. It's a basic relevancy law, and it says, hey, in these cases, we want to safeguard the alleged victim against privacy, embarrassment, stereotyping, and sexual innuendo, right? So we're trying to make sure we can stay clear of the victim blaming that often happens in cases like this. Here's a specific case out of the Ninth Circuit in 2012. It was a federal sex trafficking prosecution, and the judge basically said, hey, listen, prior prostitution by the victims, irrelevant. It doesn't matter. It's not relevant to what in this situation is the real question, which is in this situation, was force, fraud, and coercion used? A great case for those that are doing trafficking cases on multiple levels. Protective orders. Key to these cases and to any cases where women are, subjected to this, deep inquiry. So what can we do? Can we use initials? Can we use Jane Doe? Make sure that when we're redacting, we're not just looking at names and social security numbers. We're looking at phone numbers, addresses of families, locations of schools. Really make a broader idea of how to redact these cases. Privileged information, that's going to include your counseling records. Should you ever have any SANE photographs or medical records, these are protected by privilege. And they cannot be pierced by a mere fishing expedition by the defense saying, hey, judge, I want access to this because I think there might be something there. All states that have this privilege, most of them, if not all of them, have a formal process, a legal standard that needs to be met before that can be pierced. And it's a very high one, and the defense needs to be kept to that high burden before this privileged information goes out. Also, just think about other privacy concerns. I think a lot of us work in jurisdictions where we sort of have this open discovery. We're like, my file is your file. I see it more and more when we're talking about forensic forensic examinations of cell phones and of social media. Defense are asking for the victim's version of all that. And we're providing it because there is some sort of relevant information in there. But we need to be really clear about what is relevant and material to this case, and we need to make sure that we're protecting that victim privacy. Even if we think it's not a big deal, the mere fact that we're fighting tooth and nail, again, goes to reinforce that trust and rapport that we've built all along. So another thing that's important to do pre-trial is what's going to be admitted, what statements are admitted. In cases that involve lots of co-defendants and victims, oftentimes we're going to come across really these cases where we have either non-hearsay or hearsay exceptions. One of the big ones that's going to come into play here is the verbal acts. The words of solicitation or the acts of solicitation that are communicating that. So sometimes we hear cases where IMBs, the women in IMBs have been trained to not speak verbally, but to perhaps use their hands to negotiate the act. That all is not hearsay. So again, think about what that means for your cases where you may not have victim participation. Can you establish the solicitation without the victim? Yes, you can. And in Florida, in fact, I tried a human trafficking case where the victim did not testify, and it was based on the solicitation that was non-hearsay and then a bunch of digital evidence. So those verbal acts not being hearsay is really key to how we move forward in trafficking cases. But we also have lots of things like the prior consistent statement when there's an allegation of fabrication. That's going to come up in these cases if your victims are getting a lot of services or if they're getting immigration relief. Then the defense is always going to be, hey, you're testifying because X, Y, and Z. Well, there's a rule that says, hey, if the defense is saying that there's a bias to lie or a motive to lie, I can bring in all the prior statements that happened before that motive ever happened, before she ever even knew there was such a thing as a U visa or a T visa. So again, we've got the medical treatment, the excited utterance, those things that you know, and the Crawford analysis. Any questions on this, just let us know. We're also going to look at other bad act evidence. Oftentimes this requires a little extra investigation, but it's great for these criminal networks because I guarantee there's going to be some other stuff out there that would be really helpful for us. So things to think about that are helpful. There's no statute of limitations on this. There's a lower standard of proof of what's going to be admissible. And then also subsequent acts. Sometimes we refer to this as prior bad act evidence, which will hide the fact that we can also do subsequent bad acts. And that can include tampering things, destruction of evidence, flight. So good things to think about. Now, when we actually start doing our trial, these are the kind of breakdown pieces that we want to look at. Voir dire being so key, getting off on the right foot, starting that education process, opening and closing, how to direct the victim examination and other examinations, cross-examination of the offenders. These offenders have gotten away with stuff for a very long time. These guys might be the type of guys that want to take the stand and explain themselves. So you may have an opportunity to cross-examine them. And then the use of expert testimony to, again, help with that educational piece. The jury selection, you've got a lot of goals of that. Some of it's just, hey, be the likable person that the jury likes in the room. Establish that trust. But also we want to start educating and establishing empathy, uncovering those biases, and managing expectations. When I tried my first human trafficking case, the first thing I asked for was like, hey, what movie comes up when you heard this was human trafficking? They were all Taken. And so, you know, my case didn't look anything like Taken, so I really needed to make sure that jury wasn't going to walk into the room expecting some sort of evidence that I wasn't able to give them. You've got to manage those expectations. If it's not what they think it's going to look like, then they can easily dismiss it. So start talking about what trafficking really looks like in our communities, what the trauma really looks like, how coercion is usually not with a gun, but hey, what are other things that can be used to coerce? Who are the types of people that offenders go after? They go after the most vulnerable. Who could be more vulnerable than a woman in this country that may not be here legally, that may have some debts, that may have family at home that is expecting them to send back money? So start that right from the beginning. Well, as far as educating, we've got to talk about that predatory nature, just what I just was talking about, that sort of framing the offender as the predator and the victims as the prey. And that's, again, that's for the courtroom. That's for how we are going to do this to a jury. The effects of trauma, talk about, hey, like after a car accident, do you know all the details? Trying to put the jury to recognize that trauma isn't just this foreign concept, but these things that they can relate to, because they're going to have to relate to what's going on some level. Uncovering the biases. Make sure they get it, that they understand that victims may not be completely upfront, that if a victim believes they're engaged in illegal activity, they may not, come forward right away, and that coercion can come in lots of different forms, and it's not just being chained to a wall. So when we're doing our opening and closing, a big tip is to do the closing first. So what do you want this case to look like at the end of it, and then work backwards. Start with those themes. Tell a story. Don't be too fact or detail specific in your opening, because we never know how things are going to come out, right? And then additionally, there's nothing more dull than an opening statement that starts on March 25th, 2016 at 3:25 p.m. Maybe that's appropriate in some cases. It's really not here. We want to tell a story. We want to get the jurors engaged. Some offender-focused themes that I came up with that might be appropriate in these types of cases are this idea of, selling dreams, relying on the victims to not have a voice, this American nightmare, the perfect business plan, and sort of counting on no one looking as they counted their money. I think a theme like that sort of gets a jury to sort of want to be the hero for your victims. And if your jury wants to do that, everybody else has failed, that this jury feels like they want to do right. That's going to be a really strong position for you as a prosecutor. When you're doing the examination of the investigators, really talk about demeanor. Sometimes we shy away from that because investigators won't be able to talk about what somebody might have said, because that'll be hearsay. But talk about demeanor throughout the whole process. Use them as a pseudo-expert. Talk about, why did you talk to the victim, several times? Why did you do one short interview and come back? Gives the investigator an opportunity to share why they did that and sort of start talking about trauma and start talking about the need for services. And so that's a great way to, again, impress upon that empathetic nature of your jury. And when your investigators make mistakes or have misconceptions, have them right out there in the open and talk about them, because your juror is going to do that as well. And they're going to then be on the same team, right? Oh, I thought that too. I did that wrong before. And so that's a really great way to work with your investigators on the stand. Of course, let your investigators know in advance that that's what you're going to do. Direct of the victim. So if you're in a position where your victim has been supported through services and really is able to participate in the process, it's really wonderful. And so again, though, this is another opportunity, if we're not careful, and opportunity is not the right word, but this is a place where we might accidentally really re-traumatize victims. Unfortunately, we will have to ask them some detailed questions, and it may not be an 100% pleasant experience, but hopefully they're at this point really supported and working towards healing and we're able to do this in a really way that will minimize the trauma. But the first thing we need to do is we need to humanize that victim. How many times have we had a defense attorney put on a defendant and spend a half an hour talking about where the defendant grew up and where he went to school and all of that? We, as prosecutors, we're not as good at that. So we need to do that with our victims. We really need to paint the picture of, where they come from and what their hopes and dreams were and why they came here and what their fears were and why it was so important to them to be able to send money back home or to make a better life or whatever that is. We really need to make sure that we are exploring that with the victim. We also need to make sure that we're the ones that are bringing out the sting of any sort of bad facts. So those things that are challenging, things that the jury might not get that seem counterintuitive, we're the ones that need to deal with that front on and make that connection with the jury. And the best way to do that is through really recreating the reality. And we do that through those sensory questions. And as Oriene, pointed out, and this is sort of the double-edged sword, is that those sensory memories are the strongest. Research shows that even after trauma, those are the memories that victims are most easily able to recall, the senses, the five senses, and they can make that connection with the jury, those sights and sounds and feelings, but they are also the memories that can trigger the trauma. So again, this is just another place where we need to make sure we're cooperating and coordinating and doing the best we can to do no harm, but also do our jobs. So the offenders testifying, get as many agreements as possible. These are things that we know from trial advocacy 101, you own this business, right? You're a businessman. You're trying to help other people. Sometimes we have intra-cultural offenders, so the offenders may be of the same nationality, ethnicity as the victims. So, hey, you're trying to help these girls out, right? And then point out all their involvement, because remember, one of the big defenses is, I'm just the owner. I don't really know what's going on in the business. So try to figure out where you can connect them, including handling legal matters. You'll see that perhaps if the women had been arrested in the past, who are the ones that managed that, posted their bond or hired their attorneys or things like that. And then play along with their narrative if that's appropriate. Do what, what you feel is appropriate. But here are some things that might be possible coming along. So expert testimony, this is the federal rule. Again, states have things that are very, very close, have very similar language. And one of the things that I always try to point out is that it's a very low standard. It's really not requiring some super hyper-technical education and knowledge. It really says anybody with knowledge, skill, experience, or training or education may testify, if that knowledge will help the trier of fact to understand the evidence. So this is a low burden to bring in expert testimony, and in these cases it might really be appropriate. You might need it to understand the sort of networked and the financial records and the business organization, but also victim behavior. Some of the things that we talked about with the trauma and the behaviors that seem maybe counterintuitive. Can we get someone to come in and talk about how they've worked with victims of trauma and that this is not uncommon or this is common? We do it in a very educational basis. Because jurors have expectations. They all do when they walk in the room. And we either have to meet those expectations or we have to explain why not. We can explain why not, sometimes through very articulate witness testimony, sometimes through our evidence, sometimes through argument, but oftentimes expert witnesses are the best way to do that. They also help jurors determine victim credibility by placing that in the right view so that the jurors are using the right context or the right lens with which to view the evidence. And then those myths, if we don't attack them front on, if we don't talk about them, if we leave them unexplained, those jurors are going to fall back into the myths that they have about victims of sexual abuse or women that are working in massage parlors or foreign women that come here or whatever those myths are out there. Hopefully we sort of uncovered them through our jury selection, and then we're able to confront them and demystify them through through expert witness testifying. I'm going to have a couple of cases here that talk about the need and acceptance of expert testimony in cases involving, I think some of these are going to be domestic violence, some might be sexual violence, but they really go to the heart of the issue, which should be analogous to these cases, which is, hey, this victim's behavior may seem incredible, but if an expert can explain it and can explain that about these counterintuitive behaviors, then that credibility can remain. So this is a great case out of California. We also have a case, another federal case from looks like Illinois, excuse me, but it talks about how expert witnesses can also be used just to talk about how trafficking works. So what are the means? How are offenders targeting victims? How are they manipulating victims? Talking about that psychological coercion. In cases involving debt bondage, you can have an expert to sort of talk about how that works. Also, this case talks about the contributing factors to make victims vulnerable and the vernacular used. And this is not an IMB case, but it is a sex trafficking case. So going forward, we really want to implement all this trauma-informed practices. So now that we know how trauma can affect us, how do we make sure that we have everyone in our system sort of using practices that are minimizing re-traumatization throughout the criminal justice system. And then how do we prepare our cases from the very onset so that we aren't in trouble with discovery, that we are, going forward with cases using victim statements or not? How do we do all of that well in advance so then when we're at trial, we're not struggling with all those really hard decisions, and neither are our judges who may make the wrong decisions if not given the appropriate amount of time to really be briefed and understand these complex issues and new issues. And then ultimately at trial, making that offender the real focus of our trials to maximize that they are held accountable for each and every criminal activity that they were involved in, whether it be the human trafficking of these women through the sexual servitude in the IMBs to the racketeering and the networking, money laundering, and whatnot. So all of that, we need to make sure they're held accountable through this criminal activity at their IMBs. And I think that is it. I was speed talking through that. But I do want to remind you that we have part 1 and part 2 online. They're recorded and they're open to you and your colleagues. And should you have any questions, I think we do have a couple of minutes.
Thank you, Jane. Thank you, Oriene. And thank you, everyone who was here online and who listened to it on the recording. Like Jane mentioned, you can find parts 1 and 2 on our website, and I'll add this third part so that you can get it in one page. But please remember that AEquitas is available for 24/7 case consultation and technical assistance providing you with resources and advice. And so reach out to us. You will be getting the PDF of today's presentation, which also has, as you can see here, Oriene contact information. So again, on behalf of AEquitas and Polaris, we thank you for your participation and hope you all have a good day.